Hello, my brothers and sisters. How are you guys there? You hope you guys are doing amazingly well. So today we are gonna see the amendment for CA internal law. Yeah. Okay. Let's start. Which is applicable for November 2023 examination. The first one is chapter 1 preliminary. What is it talking about? It's talking about small company. Amendment is about small company. So what is small company? What is small company? The following conditions should be satisfied. What are the following conditions for which you have to satisfy it to be a small company? What are those? $50 lakhs or such prescribed amount, whichever is higher. Yes, this is with respect to super paid up share capital. And what about the next one? The turnover. What will be the turnover? 2 crores or such prescribed amount, whichever is higher. And what is the prescribed amount for paid up share capital? 2 crores. Okay. And what is the paid up share? What is the amount for turnover prescribed? It's 20 crores. This is the provision before amendment takes place. Yes, yes. And now what is the amendment? Okay, first we'll study what is the provision before amendment. As per the company's specification of definition details in 2014, for the purpose of subclause 1 and subclause 2 of clause 85 of section 2 of the Act, paid up and turnover of small companies shall not exceed rupees 2 crores and rupees 25 crores respectively. Yes, sir, rupees 2 crores and rupees 20 crores respectively. This is what we have seen, yeah. Rupees 2 crores and rupees 20 crores respectively. Yes, yes, no. Now, what is the amendment? Amendment is where instead of 2 crores, instead of this 2 crores, instead of this 2 crores, what they have changed, they have turned this 2 crores into a 4 crore. So here 4 crores. Yeah, and the paid up share capital is 4 crores and the turnover is 40 crores. So this 20 crores, this 20 crores becomes 40 crores. Sir, yes, sir. So, say in short, paid up share capital should not exceed. So paid up share capital should not exceed 4 crores and turnover should not exceed 40 crores. So why is this, sir? We have also there is something called 50 lakhs. There is also 2 crores. But whichever is higher. What is higher? 4 crores is higher. And in this turnover situation, which is higher, 40 crores is higher. 40 crores is higher. This amount has been prescribed by central government. This amount has been prescribed by central government in this rule, company specification definition details rule 2014. Yes. And what about center? How much a central government can specify? Can they specify some 2000 crores? No. Can central government specify an amount of, let's say, 200 crores as paid up share capital? No. Why no? Because maximum they can, lawmakers have said the maximum you can go up to 10 crores. But central government has went up to 4 crores. And what about turnover? Turnover maximum they can go up to 100 crores. Yeah. So what is the most important thing in here? The most important thing is 4 crores. This is the amendment made, and 40 crores. Is it important? Yes. And so is amendment important? It's extremely important. Why is it important? Okay, I'll give you with my practical scenario example. In when I wrote my direct tax examination for CA final law, CA final direct tax, 70% questions came from amendments. 70%, and that too direct question, direct. Only amendment came around 40%. 40% direct, remaining 30%, there were a lot of indirectly they have inserted the amendment. So amendment became very important in that particular examination. And why I am particularly saying that is because 70% marks came from that. So those brothers and sisters who studied amendment would have done very well, exceptionally well. Though so amendment is not like sometimes they'll only ask for 4 marks. Sometimes they can take that amendment and completely insert it into the question paper. So amendment is important. Yes, yes. So we'll rub again all these. So what is a small company? What is a small company? Following conditions to be satisfied. With respect to paid up share capital with respect to turnover. Paid up share capital 50 lakhs or prescribed amount. What is the prescribed amount? What is the prescribed amount that has been amended? How much it is? 4 crores. This amount can be this amount who has made the change. Central government. Central government could have gone up to 10 crores. They went up to 4 crores. Whichever is higher. Whichever is higher. 50 lakhs or 4 crores, whichever is higher. And what about the turnover? So what about the turnover? 2 crores or what is the prescribed amount? 20 crores? No. What is it? Prescribed amount 40 crores. So 2 crores of 40 crores, whichever is higher. What is the higher amount? 40 crores. So for if in a company, if a company whose paid up share capital is 4 crores and whose turnover is 40 crores, they can what? They can have the company said as a small company. Otherwise, it is not. So it is a public company, holding company, subsidiary company, Section 8 company, special company. All these are these companies a small company? No, this is a particular exception also. Yeah, yeah. So this is what is an amendment. No. Chapter 1, this is the amendment. Now let's go to chapter 2 amendment. So what are they talking about chapter 2 amendment? We are talking about section 16. Section 16. So what is the section 16? Compulsory change of name. Compulsory change of name. And what have they said? Let's say. This is the old provision. on an application by a registered proprietor of a trademark that the name is identical with or too nearly resemble to a registered trademark of such proprietor. And it may direct the company to change its name. The company shall change its name or new name as the case may be within a period of 6 months from the issue of such direction after adopting an ordinary resolution for this purpose. What are they saying? So what are they saying? Writer of a registered trademark. What are they doing? They are making an application. They are making an application. Who are they making an application to? They are making this proprietor of registered trademark is making an application to CG. Is making an application to CG with respect to what? The name of a company. The name of a company is identical or to resemble. The name of a company is identical or too nearly resemble of a trademark, too nearly. Okay. In this situation, central government making an application, what central government will do? Central government is of the opinion. Central government is of the opinion that yes, it is either identical or yes, it is either too nearly resembles. It is either identical or it is either too resembling the name of the trademark. Name of the trademark. Then in that situation, CG central government directs. In that situation, central government directs company to rectify its name. Directs company to rectify its name. And company has this is the provision. Okay, this is the provision. Now, company will rectify its name. This is the provision. Have you understood? Yes. So company will rectify. When will company rectify its name? This is the main pro. This is the amendment. Company shall rectify a name within 6 months. This is what you know. Company shall rectify the name within 6 months of direction of CG. Direction of CG by passing ordinary resolution. By passing ordinary resolution. This is the provision you know. This is the provision you know. Now, what is the amendment? In subsection 1, in clause B, for the words period of 6 months, the word period of 3 months shall be substituted. What is saying? Instead of this 6 months, they are telling to what? They are telling to substitute it into 3 months. This is the provision. This is the provision. Now let's take an example of this complete scenario. So the provision, the amendment is only this, 3 months. Instead of 6 months, convert into 3 months. But still, we will do a small revision of this provision. Okay. Let's take a registered trademark. So what is what trademark? Let's say there is a registered trademark. Let's say there's a registered trademark of what? Sony. Registered trademark of Sony. Yeah. This Sony is making an application to CG. What? The name of the company is identical. Another company has named their name Sony. Another company has named their name Sony, or they have named it is the name is too nearly resembling the trademark, either Sony or SONIE, Sony. It's what the name is too nearly resembling the trademark. What is the name of the trademark? It's Sony, SONY. But another company is also either giving the same Sony or SONI. It's too nearly resembling. In that situation, CG is also of the opinion, yes, the application given by the Sony company is right. It's what it is right. So CG is directing the company to rectify its name. So company has to rectify its name by passing an ordinary resolution. But when earlier you said it's 6 months, but now with the amendment it is 3 months. With amendment, it is 3 months, sir. Yes. No. This is one another provision. If company makes default in complying with any direction, what that CG has told to change the name and company has not changed, then this is the liability. What is the penalty? This is the penalty for company and officer in default. This is the provision. Now this has been amended. What is the amendment? If a company is in default in complying with any direction given under subsection 1, the central government shall allot a new name to the company in such manner as may be prescribed, and the registrar shall enter the new name in the register of companies in place of old name and issue a fresh certificate of incorporation with new name, which the company shall use thereafter, provided that nothing in this subsection shall prevent a company from subsequently changing its name in accordance with the provision of section 13. So what is it saying? Sir, earlier we saw, CG is directing to change the name within 6 months. You have to change. That has been converted in 3 months. Okay, but company is not rectifying the name. Company is not rectifying the name, so that this is the penalty. This is the penalty we have studied. This penalty is now converted. Now, what is the provision? Now, what is the provision? Company, where can I write? Company makes a default. Company defaults in complying the directions. Company defaults in complying the direction of central government. What will central government do? Central government shall. This is what the provision is. If company defaults it earlier, what they will be punished. Company and office and default will be punished. Now the new provision. Company shall allot the new name. The company shall allot the new name. Who will allot it? Central government will allot it. So company will be allotted by the name by whom? CG. So CG shall allot new name to the company. New name to the company. Yeah. And what? Registrar shall enter new name. Registrar shall enter new name. What? New name in register of members. Registrar shall enter new name in register of not members of not register of companies. What? In place of old name. Yes. So what is so the amendment is still not over. Let's take an example. Central government has told, oh God, what is the new some good name? No, we don't want a good name. Central government gave what? 3 months amendment. 3 months central government gave. Still, company has defaulted in complying the direction of CG. Yeah. So CG, what they did, they gave a name. What? Ramaya Vastavaya. Say okay. Let's say Vastavaya. Vastavaya. Aha. And this is the name of the company. Okay. Limited or private limited. So Vastavaya Aha is the name of the company CG has allotted. Can CG do it? Yes, CG can definitely do it. What CG has allotted the name. And what registrar? What will registrar do? Registrar will enter in the register of companies. This has a new name. Yes. No, what? Will the company be happy? No, hell no. Why will the company be happy? The what? The name is something. So your name. Let's take your name. No, I'm saying just for the importance of it. Your name, sir. Your name, a good name. For example, Ram to Raman. A good name. I don't know, sir. I don't know. A good name. Let's say from one name. Still, the name which you want was already there. Someone is replacing that into another good name. But still, the name which your parents have given you is more important. So, yes. Will you like to have the same name? Yes. Yes. So, what what central government, then think about this. Central government has given a Vastavaya, haha. Listen. So is no is the company in trouble? Yes, company what is irritated. So what can a company do? Lawmakers told nothing to worry, nothing to worry. You can change the name. Subsequently, company can change its name. Company can change its name. This will not be prevented. This will not be prevented. This will not be prevented. Subsequently, company can change the name and this will not be prevented. Sir, yes or no? Yes. Now, do you want to study this or already have you understood it? I hope you guys understood this provision. Yes. Yes. This is what chapter 2 amendment. Now let's go with chapter 3 amendment. So is this amendment good? Yes, this amendment is good. Chapter 2 amendment. This reason is, sir, let's say a person and a penalty of some 5,000, 1 lakh. A person has a lot of money. So you establish the company which is going in lakhs and crores, and someone used the name of your company, and instead of people purchasing your brand, they are purchasing some other brand. So the name is very important. So the lawmakers has made a very good initiative. Now coming to chapter 3. Chapter 3 amendment. This is this amendment is with respect to Rule 14. Rule 14 private placement. It's a new insertion. The fourth proviso. After fourth proviso, it's a new insertion. Yeah. What is it? So first of all, what is private placement? What is private placement? Company is giving an offer of private placement to public? No, not to public. That is a public offer. Company is giving private. They are giving to specified persons. Yes, yes or no. For example, birthday party. Your birthday party. Will you call the entire public for your birthday party? No, you will give an invitation. You give an invitation to whom? To the loved ones who you want to invite to the party. Yes or no? Yes, and they will either willingly love to come to you, otherwise they may have some other important things to do. So they might say, I'm unable to come, but still happy birthday. Yes or no? Yeah. So the same way, this is what is private placement. Yeah. So we already know this. I just told you. I'm sure you already know this. Yeah. No. No. What is the amendment? Provided also that no offer or invitation of any securities under this rule shall be made to a body corporate incorporated in or a nation of a country which shares a land border within India unless such body corporate or a national, as the case may be, having obtained government approval under Foreign Exchange Management Act Rules 2019 and attached with the same with the private placement offer come application letter. What is this? What is this? The company. The company what is giving private placement. Private placement. Private placement. Yes. To whom? Can it give it to the public? No, we just saw. We just you already know, but we also just revise. No, it cannot be given to the public. It will be given to few individuals. Yes or no? Let's say they are given. They are giving to. They are giving to a nation, and they are giving to either a national of a country which shares a land border with India. Okay. Or company gives private placement to a body corporate of a country which shares a land border with India. So have you understood it? Let's say. So, sir, our country shares our border with another country. Who we so give me one or two countries name. Okay, Bangladesh, China, good. So let's say let's say our company, sorry, our company, AANIM Limited is giving private placement to Chin Chan. Who's the Chin Chan? Who's the Chin Chan? A person's name is Chin Chan, and he's what? He's a Chinese person. He's a Chinese person. China is what sharing a border with India. China is sharing a border with India, or company what is giving a private placement to Sunyon Limited, Sunyon Limited, which is a body corporate. Yeah, this is also Chinese company. This is a Chinese body company. What which is this Chinese company? What this it's sharing a land border with India. Yes or no? Yes. If company is giving a body corporate, so this provision is with respect to where company is giving an individual who this individual is who's this individual? This individual is a person who's sharing a kind of land border with India or yeah or a body corporate. So an individual or a body corporate, that person is what he's sharing. That person is a person who in that country and in our country we are sharing the for example let's take I'm an Indian. Okay, I don't want to say I'm not an Indian and what Chinese person. I'm the company. I'm giving I'm giving Chin Chan what a private placement or offer come application. Yeah, yes or no? Yes. Can I give it? Yes, I can give it. Earlier, there is no problem. Earlier, there is no problem. Now, there's a problem. What? They are telling that if you want to give to if you want to give a nation means a person or a body corporate, oh that person is sharing land border with India. Let's say some Donald Trump. Does he have any problem with this? No, no problem. This US sharing this US is sorry, that is not this is US sharing land border with India? No, no problem. What about China? Yes, it's sharing. So in that situation, company has to do what? In that situation, what is it? That national or that body corporate. So in our example, Ching Chan or Sunyon Limited, Sunyon Limited. This person has to what? Has to obtain approval from our government, has to obtain approval from our government. Now, this is what it is. Earlier, there's no problem. Any person can come and have it, but now there is a problem. Why is there a problem? So why this pollution? Answer is very simple. The Chinese national and body corporate are the ones who's investing more in India, and what there was a Chinese attack. They are trying to take our land border. So what did India do? Lawmakers made a provision that we want to know who and all are the person who is trying to take a private placement, and with the approval only you can have it. With the approval only you can have it. Yes, yes. So this approval is under FEMA. This approval is under FEMA. Yes. So along with this approval, along where you are giving your private placement, where you are giving is PPQMA, which is private placement offer come application letter. Private placement offer come application letter. You have to also give the approval from government. Then only you can get what? Then only you can get the private placement. Is all. Yes. This is one provision. Next. This is a simple provision that it has been omitted. One provision has been omitted. What is it? That attachment of resolution in case of bonus shares. Rule 12 sub-rule 6 states that in case issue of bonus shares, a copy of resolution passed in the general meeting authorizing issue of such shares shall be attached to form PAS3. So in form PAS3. So this provision has been omitted. You don't have to attach anymore. No. So now let's go with next chapter amendment, chapter 5. Chapter 5. What is chapter 5 saying? This is the old provision. A duly audited return of deposits in form DPT3 shall be filed with the registrar of companies along with the requisite fee on or before 30th June of that year. Sir, I hope you guys know this provision. I hope you guys know this provision. No. What are they saying? This is the provision. No. There is some insertion. There is some insertion. What is insertion? The word, the letter and figure and. This is the insertion. The declaration to that effect shall be submitted by the auditor in form DPT3. Yes. Few information with regard to the deposit. Few information with regard to that deposit. The auditor will do what? Auditor will file a return. To whom? To the registrar in form DPT3. So auditor will file a return with regard to deposits. To whom? To registrar in form DPT3. Sir. Yes, sir. Now what is the amendment? Amendment is along with it, a declaration is also given. Auditor is also giving a declaration. What in that return? Auditor is also giving a declaration in the fact that to that effect shall be submitted by the auditor in form DPT3. What is this? That whatever the return, whatever auditor has prescribed in the return. All the information is right to his knowledge and belief. Yeah. This declaration will be given by the auditor. This is the amendment. Sir, yes or no? Yes. So this is chapter 5. Now let's go with chapter 6. What is chapter 6? Registration of charges. And so what, you know what is charges for? Yeah. Yes. So what is charges? So for example, you are giving loan. You are giving loan to X or Y. You are giving a loan to X or Y. Will you just give a loan simply like that? No. What do you want? You want that amount to be returned back to you. What is the guarantee that that guy will return back to you? So that what? You will get a what? Security. You will get some asset. Yeah. That particular security, that particular asset what? Will be what? Registered as charge. Yeah. No. So any particular asset is what? You you will what? You will give a loan. You will give a loan. You will give a loan only if what? Only if an asset is given. Only so simply put, charge should be the asset. The charge should be created. It should be registered. Yes or no? Yes. So now with regard to charge which has to be registered, with regard to charge which has to be registered, this is the amendment which has been newly inserted, Nothing contained in this rule shall apply to any charge required to be created or modified by a banking company under section 77 in favor of RBI when any loan or advance has been made to it under Clause D of Clause 4 of Section 17 of RBI Act 1934. What is it? What are they saying, sir? I'll give you 5 seconds and think. Got it, super. I know you will get it. Now what are they saying? Let's say, sir, tell me a name of bank. Okay, we'll take SBI. We'll take SBI Bank. This SBI Bank has given a loan to has received, let's say, SBI Bank has received either a loan is given or advance has been made. Okay, let's take RBI. Let's say RBI. Let's say RBI has given a loan. Let's say RBI has given a loan to SBI, or let's simply say, right. Let's say SBI has given a loan to RBI. Let's say SBI has given a loan to RBI. Should they do it? Tell me, should they do it? Should they register it? Simply, should the charge be registered? Think and tell me. Should the charge be registered? Either it should be created or it should be modified. Either it should be created or it should be modified. Answer is not required. With regard to RBI, you don't have to do this. This is the new provision. This is the new provision. Sir, yes or no? Yes. charge required to be created or modified shall not apply to shall not apply to like in case in favor of RBI of where any loan or advance is made by banking company. Yeah, that's is charge required to be created? No, it should not be. It should be created. It should be created. Yes or no? But in case where any loan or advance is made by a banking company, in favor of RBI, should the charge required to be created or modified? Not required. Not required. This is the one. This is one amendment. Next amendment. This is also newly inserted. This is also newly inserted. What is the what is it? It is with regard to signing. It is with regard to signing. What is it saying? Signing of charge e-forms by insolvency resolution professional or liquidator for companies under resolution or liquidation. The form CHG1, CHG4, CHG8, CHG9 shall be signed by insolvency resolution professional or liquidator for companies under resolution or liquidation as the case may be and filed with the registrar. What does it say? So first of all, it's talking something about signing. It's talking about with regard to signing. Signing by whom? Signing by insolvency resolution professional, liquidator. So who is this here? Resolution professional. This is with regard to this topic is in CA final. This chapter is in CA final. What is the topic? Insolvency and bankruptcy code. IBC. Insolvency and bankruptcy code 2016. Yeah, a very interesting chapter. This in this chapter, for example, a creditor where a company has to give an X amount of money to the creditor. What the creditor, but the company is not repaying. The company is not repaying. What the creditor can go to the tribunal. The creditor would go to the tribunal and ask for what? Ask for money. Tribunal will say yes, okay. I will I will tell them to I will tell them to pay the money for that what an insolvency case will take place, and this is where insolvency resolution professional is appointed. Next, a resolution professional is appointed. Still, this is first situation. This is second scenario, and still, if the payment is not being done, then liquidation takes place. Liquidation takes place. Then liquidator is being appointed. So still unable to understand, it's completely fine. It's completely fine. A creditor will go to tribunal. Tribunal will appoint either insolvency resolution professional. Then the resolution professional will take care of it. But still insolvency, but still the amount is not being given. Then in that situation, liquidation will take place. Liquidation will take place. In that situation, liquidator will be appointed. Yes, this is the scenario with regard to IBC 2016. So either the resolution will be passed or the liquidation will be happening. Either resolution will be passed or liquidation will be happening. So where a resolution is passed, let's say where a resolution is passed, in that situation, insolvency resolution professional or resolution professional will sign e form. What form? CHG1. What is CHG1? Other than debentures. Superb. Creating or modifying charge other than debentures. What is CHG 9? The creating or modifying charge with respect to debentures. What is CHG 4? Satisfying the charge. Okay, what is CHG 8? You tell me. Superb. This is with regard to extension of time given by central government in regard to creation or modifying. So these forms where a resolution has been passed, either insolvency resolution professional or resolution professional will sign these forms, but liquidation takes place. What takes place? Liquidation takes place. In that situation, liquidator will sign this form. Liquidator will sign this form. Yes. So either a resolution is taking place or a liquidation is taking place. Resolution is taking place, then insolvency resolution professional will sign it or resolution professional will sign it. Liquidation is taking place, then liquidator will sign it. What will they sign? So what will they sign? They will sign either CHG1, CHG4, CHG8 or CHG9. Yes? Yes. And this will be filed. And this will be filed with the registrar. This will be filed with the registrar. These persons will sign it. Yes or no? This is the amendment. This is the amendment. Yeah. No. Chapter 7. Shall we go with chapter 7? So this is already previously there, but still they have also again included again. What is it? Rule 14. Rule 14, where it is saying that members or debenture holder they can get what? They can get what? They can, if they want, they can do the inspection. They can do the inspection or they can get an extract. They can get an extract or they can get a copy of what? They can get a copy of what? Register, index or return of who? Of member. So what if a member wants to inspect the register of member or return of member, can they do it? Yes, they can do it. They can do it. Now, what is the main thing? But four things cannot be. But four things cannot be given. Four information cannot be given. What are the four information? One is address or address of the member, and if a member is a body corporate, that registered address. Next is email. One is address, next is email ID. Next is unique identity number, and next is PAN number. These and all are very personal. Just because company wants this information. I am ready to give this information to the company, but I don't want any other member. If they want my email ID, my address, my PAN number, I don't want that information to given to any other member. This information should be here. So lawmakers, what they did, yes, you want, you can inspect, you can extract, you can copy of register of members, but these information will not be given. These information will not be given. Yes, yes. So no. We will go with chapter 8. We will go with chapter 8. What is chapter 8 talking about? IEPF. What is IEPF? Investor Education and Protection Fund. Investor Education and Protection Fund. What is it, sir? It's a fund where some amount will be credited into this investor education and protection fund. There is a list for all these that particular items. That amount will be credited to investor education and protection fund. From that list, that list is in rule 3. That list is in rule 3. In that, one particular point has been included. One particular point that insurance. So even this also will be included in the investor education and protection fund. So what is this new point? All shares held by the authority in accordance with the proviso of section 90 of subsection 9 of the act and all result benefits arising out of such shares without any restriction. What is it? So what is section 90 subsection 9 of this act talking about? SBO. What is SBO? Significant beneficial owner. Who is the significant beneficial owner? Who is holding more than 10% of the voting, dividend, or securities? Yes. These person has to give a what? Has to give a declaration. But these person are not giving a declaration. In that situation, company can go to NCLT, company can go to a tribunal and ask and report it and considering the scenario, tribunal will say you can do what? The shares of this significant beneficial owner, the shares of the significant beneficial owner will be credited to investor education and protection fund, will be credited to investor education and protection fund. And for example, a bonus share is given to investor education protection fund, which is a benefit, resulting benefit. What is a resulting benefit? This is the share of what? Yes, a significant beneficial owner. Because of this share only, a bonus share is being allotted or a dividend is being given. This benefit arising out of shares, a bonus or dividend, this also will be given. This also will be credited to investor education and protection fund without any restriction. Yes. So let's read it again. All shares held by the authority, all shares held by the authority with in accordance with section 90 subsection 9. Because tribunal says you what this particular share transfer it to investor education and protection along with that share. All resultant benefits arising out of the shares without any restriction. So you what without any restriction, the benefit also will be credited to investor education and protection fund. This is newly inserted. Now, chapter 9. Chapter 9. We'll start with the first itself. In continuation to Ministry General. Oh God, I have to read all this. So nothing, sir. What is this? See, this is talking about CSR activity. This is talking about CSR activity. Yeah, Schedule 7. So in this, lot of companies has invested in COVID, they spend a huge amount of money so that the public can what they want to help public, they help them. So lawmakers okay thought that what for those companies CSR is applicable. So even this COVID related thing can also be included. So with regard to that, COVID-19 is an eligible CSR activity. It is further clarified that what spending of CSR funds for creating health infrastructure for COVID care. What I have spent some infrastructure so that people can come in, and stay in that particular care. Establishment of medical oxygen generation, storage plants, manufacturing and supply of oxygen concentrators, ventilators, cylinders, and any other medical equipment for countering COVID-19 or similar such activities are eligible as what? CSR activity. And this is what? One is in Schedule 7, Item 1, which is preventive healthcare, and point 12, which is disaster management. This is a disaster management. Definitely, COVID-19 is an absolute disaster management. If you remember, you could know that lot of people are unable to what enter the hospital, even though they are COVID affected. They are because hospital was filled with COVID patients. Even you could, people were burning the bodies of dead bodies in the streets. If you remember, it was so sad. It was a disaster. In that situation, company what if they helped in either some creative infrastructure or some giving oxygen storage plants ventilators, cylinders, other medical equipment. In that situation, this should be considered as what? A CSR activity. Next. Reference is also drawn to item number 9 of Schedule 7, which permits contribution to specified research and development project as well as contribution to public funded universities and certain organizations engaged in conducting research in science, technology, engineering, medicine as eligible CSR activities. Sir, yes or no? Yes or no? Yes. Even with regard to even also what are they talking about? Some research has been conducted with regard to science, technology, engineering, medicine. This is also a CSR activity in item number 9 of Schedule 7. Yes, yes. Next. Companies, including government companies, may undertake the activities or projects or program using CSR funds directly by themselves in collaboration as shared responsibility with other companies, subject to fulfillment of CSR rules and guidelines. So you can also do what? You can also share the responsibility only yourself, only the company itself, or along with other companies also. Yes, yes. So creative health infrastructure for COVID care, oxygen generation establishment, storage, plants, ventilators, cylinders, other medical equipment. This and all will be considered as what? Either it is a can be considered as preventive health care or will be considered as disaster management as per Schedule 7. As per Schedule 7, this is item number 1, this is item number 12. Next, if you're doing any science, if you're doing any research related activity with regard to science, technology, engineering, medicine, this also would be considered as what? A Schedule 7 activity. A Schedule 7 activity as per point 9 of Schedule 7. The Ministry of Corporate Affairs clarified that spending of CSR funds for COVID-19 is an eligible CSR activity. In continuation to the said circular, it is further clarified that spending of CSR funds for vaccines of person, this is the most important. For person is an eligible CSR. It is an eligible CSR activity. What? For if you want for COVID, it is an eligible CSR activity. But other than employees and their families. Other than employees and their families. For example, you're giving COVID care. You're giving COVID care for your employees, or you're giving COVID care for the employees' families. Then in that situation, will it be included in the preventive healthcare point 1 of Schedule 7, or will it be considered as disaster management of point 12 of Schedule 7? No. You have to give it to the public, not to the employees or employees' families. Yes or no? Yes. Next. Gar Har Ghar Tiranga. What is this Har Ghar Tiranga? if you remember, in the balconies, Indian flag was being hosted in almost every house, every single house. Do you remember? Yes. A campaign has been issued under Azadi Ka Amrit Mahotsav. Yes. Do you remember? Just uh, Indian flag was very important, and as per article, you can you if you want to go say something against it, you can wave the Indian flag, and in favor also you can wave the Indian flag. Okay. So this particular thing, this particular where every household was in the balcony, they were hosting this Indian flag. So in this regard, in this Har Ghar Tiranga, it is clarified that CSR funds for which a mass scale production and supply of national flag. Yeah, if you can't the government don't expect you to just do the stitching and host it. They are you buy from outside. For that, if every household requires that, then it requires a mass scale of production. Yes, yes. For this will be what? This will be included in the CSR activity. This will be included in the CSR activity in item 2, pertaining to promotion of education related to culture. Yes, this is a new insertion. No. AOC4. Form AOC4. This has to be what? This particular form, what is form AOC4? Filing financial statements. Filing financial statements with to whom? To registrar. And what is AOC4 XPRL? Extensive Business Reporting Language. Yes, this is applicable to whom? Listing company and who am I also? Turnover 100 crores or more. Yes, and Indian accounting standards. Those who have to comply, they have to comply it. So these particular for them AOC4 XPR will be applicable. Others AOC4 will be applicable. Financial statement has to be filed accordingly to the registrar. Yes or no? Yes. No. What is the changes? You have to along with it, you have to give what? You have to file form CSR. So along with form AOC4 or AOC4 XBRL, after that you have to do what? You have to file form CSR form CSR2. This you have to do separately. Okay. You can go along with it, or you can what? You can do separately. When you have to file this, form CSR2, when you have to file this form CSR2, there's a lot of date given. First, should I mention the date or okay? I'll tell you one by one. First, they have mentioned this. Where is it? Yeah. First, they have mentioned this 31st March 2022. Then they have mentioned this. They have mentioned this 31st May 2022. Then they have mentioned this 30th June 2022. Simply put, this form, you have this form for financial year 2021. First, it was what? March. Then it became May. Then it became June. So we'll write directly within 30th June 2022. You have to do the filing. You have to do the filing of CSR2 for financial 2021. And for financial year 21-22. For financial year 21-22, you have to do it on, where is it? 31st March 2023. Yes. 31st March 2023. This is what is the provision with regard to this. All this is this. Do you want to? I hope you guys do this. I hope you guys just read it. It's a very simple one. This is what it's saying. You have to file form AOC 4 or AOC 4 XBRL to the registrar. Along with it, you have to file what? File form CSR 2. Yeah, this form CSR 2 for financial year 2021, you have to file within 30th June 2022. For financial year 21-22, you have to file within 31st March 2023. Next. Books of accounts. Books of accounts. Let's say should I write this? It will take a big page to write. We already know this provision. Should I write it? Books of accounts and other books and papers. This what? This should be accessible in India. Okay, so books of accounts and books and papers. This is accessible in India. This is with regard to what? Electronic mode. So you can't expect to do manual entries now. It's very hard. How many transactions is going on? It's not like in one day there are only 10 transactions. There are countless number of transactions going on. You can't expect it to be in manual mode. So electronic mode. Earlier it is accessible. Earlier this is what? Earlier it is the books of accounts and other books and papers. What? Which it should be accessible in India. Yeah, what if it is maintained in electronic mode? It should be accessible in India. What is the new point? New point is they have added these three words at all times. At all times. It should be accessible in India at all times. Sir. Yes. Next. The word periodical basis. What is it they are talking about? Backup. Electronic mode, the books and papers and books of accounts and books and papers, where it is in electronic mode, you have to do the backup. You have to do the backup. Now, you have to do the backup. It doesn't matter. Even if the server is located here, there, it doesn't matter. You have to do the backup. Earlier, it is in periodical basis. What is periodical basis? So it is based on the company, whether according to company, they want to do the backup 1 week, they want to do the backup of 1 month, they want to do a backup 3 months, 4 months. No, this periodical basis has been converted into daily basis. Daily basis, you have to do the backup. Simple. Backup. Books of accounts and books on papers has to be done of backup. Backup has to be done. Backup has to be done on a daily basis. On a daily basis. Yes. Next. A new insertion. What is it? Where the service provider is located outside India. The name and address of the person in control of the books and accounts and books and papers in India. So you have to what? So the service provider details is even if he is outside India, it's what you have to mention it. But the person who's controlling the books, who's controlling the books and books of account, books of papers in India, his name and his address. His name and his address should be Name and address of person in control of the books. Has to be made, but this is with regard to where service provider is located outside India. The server is located outside India, then in that situation, you have to mention it. So let's say if the service provider is in India, then what you will know who's controlling the books of account, which board, which director is in control of it. Otherwise, this is outside. This is outside. In the situation, the name and address of the books and accounts and books and papers, his name should be mentioned. No. Let's revise CSR. So what is CSR? It should go where net worth is 500 crores or more, where turnover is 1,000 crores or more, where net profit is 5 crores or more. In that situation, what? 2% of average net profit of receiving 3 financial years. What you will give us company, you means company will give us CSR. Okay. If CSR is given, if CSR there's an obligation, if company has to spend an amount of CSR, should it have a CSR committee? Should it have a CSR committee? Yes or no? Why yes or no? Why yes or no? If the amount spent, if the amount spent is more than 50 crores, if the amount spent is more than 50 crores, then only CSR committee is required. Otherwise, CSR committee is not required. Yes or no? Yes. No. No coming to the amendment. It is a newly inserted one. It is a newly inserted one. Provided further that company having any amount in its unspent corporate social responsibility account of section 135 of subsection 6 shall constitute a CSR committee and comply with the provision contained in subsection 2 to subsection 6 of the section. What is it saying? What is it saying? Let's say an ongoing project. An ongoing project. And okay. So what is the let's say company has to spend 2% of the average net profit of the 3 immediately preceding financial year, let's say 1 crore. Let's say for easy calculation, I'll take let's say 1 crore. And amount spent is we'll take 3 scenarios. Amount spent is CSR amount is 1 crore. Amount spent is spend, unspent, spend. How much is the amount spent? Let's say give a number 30 crores. 30 crores is spent. 30 crores is spent. So remaining 70 crores is unspent. 70 crores is unspent. Second situation. Let's say 70 crores is spent. 30 crores is unspent. Let's take third situation. And third situation, no, these are the two situations. Tell me, now the question is CSR committee required to be formed? Now we will see. the amount this company has to spend what? What is the amount company has to spend? More than 50 crores. More than 50 crores. How much is the amount spent? 30 crores. How much is the amount spent? 70 crores. Which one will you? Which company? For which situation CSR committee will be taken? This one or this one? Both the situation. Amount has to be amount to be spent. It's not spend an amount of CSR. Amount company has to be spent. To be spent. To be spent. So 1 crore is the amount. So they have to form a CSR committee. No, I'll change. No, I'll take it. This online project is, let's take 10 lakhs. Let's take 10 lakhs. How much? Where they have spent? Uh, they have spent 3 lakhs. But unspent is 7 lakhs. Now tell me, how much should they form as a CSR committee? Answer is no. Why? Because it is not more than 50 crores. How much? What is the amount to be spent? 10 lakhs. It is not more than 50 crores for you. According to you, CSR committee is not required to be formed. Now coming to amendment. Any amount, of unspent CSR account, it is there. Any amount of unspent CSR is there in that situation. It shall constitute a CSR committee. It doesn't matter. It is less than 50 lakhs or not. You have to do what? You have to form a CSR committee. Yes or no? Yes. No. A provision is omitted. What is the provision? If it ceases, what ceases? Ceases to cover subsection 1 of section 135 for 3 consecutive financial years. Then it is not required to form CSR. It doesn't have to comply section 135 of subsection 2 to subsection till such time it meets the criteria. What are they talking about? What are they talking about? Let's say 19, 20, 20, 21, 21, 22. Net worth, turnover, net profit. The net worth, the net worth is, let's say, 100 crores. The turnover is 700 crores, and net profit is 4 crores. Is it required to? Is it met? Is that this met? No. Already CSR has been met. Next year, this is what is happening. CSR is not met. Is there any problem? No. We will see for 3 years, for 3 consecutive years. We could see a amount, yeah. 100 crores. I don't want 700 crores. 600. Let's say 600 crores, 3 crores. 50 crores, 500 crores, and 2 crores. 2 crores. So for 3 years, this has not been met. Then in that situation, CSR committees, no CSR obligation. Year after, no CSR obligation until you meet the criteria again. So for example, from 2022, 23 to 27, 28, it has not been met. On 28, 29, it is met. CSR award now, if 28, 29, any of these condition is met, then CSR you have to comply. CSR obligation is required for the company. Obligation, yeah. Now the amendment is, this has been omitted. This 3 consecutive year amendment has been omitted. So every year you have to see preceding year whether net worth, turnover, net profit is complied or not. Sir. This has been omitted. No. Bo- What is the old law? Board shall ensure that CSR activities are undertaken. Board shall ensure that CSR activities are undertaken either by the company itself or by the company which has been established under section 8 of the act, or registered trust or registered society. This section 8 company, registered trust or registered society has been established by CG or SG. So this company, so a company has a CSR obligation. They can take the help of these companies which has been established by central government and state government and fulfill their obligation. Next, or else any entity established under Act of Parliament or state legislature. So this company can take the help of this entity and fulfill the CSR obligation, or the company established under Section 8 or registered public trust or registered society or registered under section 12A and 80G of Income Tax Act 1961. This has been established by the company. What is this talking about? The company itself is a section 8 company or registered public trust or registered society or registered under section 12A or 80G of Income Tax Act. In that situation, what you can do it, or along with the company either they are doing it singly, or they are what they are taking along another company also they are taking the help and they are fulfilling the CSR obligation. This is one thing. This is point A. What is point D? This point D is talking about the same person, but this is not the company itself. This is a third party. Yeah. So this is the old provision. Now, what is the amendment? This is the amendment. This is the amendment. They have inserted these. They have inserted this one. Yeah. So section 10 23C, section 10 clause 23C of subclause 4, which talks about charitable organization, subclause 5, which talks about religious organization, subclause 6 and subclause 6A, and subclause 6A, which talks about education. So charity, religious and charitable education institution of section 10 clause 23C of Income Tax Act 1961. If a company or any other company, if they have what they are doing CSR, this is also applicable. This particular act is also applicable. Yes or no? So yes or no? So last point. So what is impact assessment? Company which undertakes company which is undertaking impact assessment, company which is undertaking impact assessment, what they may book expenditure, they can book expenditure, as CSR expenditure for that financial year, but it should not exceed. This is the approach. It should not exceed book expenditure, CSR expenditure for that financial year, which should not exceed 2% of total CSR expenditure of that financial year or 50 lakhs, whichever is lower, whichever is less, whichever is lower, whichever is lesser. Whichever is I solved, okay. So earlier it was 5% of total CSR expenditure of that financial year or 50 lakhs, whichever is less. Yes. Now what is the amendment? Instead of this 5%, they have told 2%. Instead of this 5%, they have told 2%. And instead of this less, they have told whichever is higher. Whichever is higher. Sorry, sir. Let's take so what is impact, by the way? Okay, this is what is the provision. This is what is impact assessment, by the way. Let's take just simply take, let's take water. They're supplying water bottle. They're supplying, a company is supplying water bottle to the public. So they have set a place to give a water bottle, but nobody is buying it. They have spent like 3 crores for that setup and water bottle, all the expenditure as CSR expenditure, but nobody is buying, nobody is benefiting from it. What is the requirement for CSR? So which is in the for the 3 years, if it touches 10 crores, for 3 years, if it touches 10 crores, then more than for the project where the project has been more than 1 year. The project is going on more than 1 year. Then only impact assessment can be made. Then only impact assessment in that project. What it has to touch 1 crore or more. It has to touch 1 crore or more. In that situation, they will do an impact assessment. And if this impact assessment, if they have done, you can consider this expenditure as CSR expenditure. You can consider this expenditure as CSR expenditure, and 2% of total CSR expense of the financial year of 50 lakh service a year. Sir, yes or no? Sir, yes or no? Yes. So what is small company? What is small companies amendment? What is small companies amendment? The prescribed amount has been increased from 2 crores to 4 crores, and turnover increased from 20 crores to 40 crores. And this, and what about this trademark section 16? That, tell me, sir, please tell me. Instead of 6 months, they have changed it to 3 months. And next is, if company has defaulted in not changing the name, in that situation, CG will allot the name, and what registrar will registrar will enter in the register of companies that new name which CG has set, and this will be subsequently changed if company wants to. Next, private placement. A country which shares border with India, that individual, that national or that body corporate is what he has been offered private placement, not on along with private placement or come up application. They will also give approval from the government. Yes or no? Form in case of bonus shares, you have to give form PAS3. This has been omitted. Auditor, while they file form BPT3 for deposits, they will also give a declaration to the registrar that the information mentioned in this return is correct. Next, with regard to Chapter 6 registration of charges, it's a new insertion. What is the new insertion? If a banking company has given a loan or advance in favor of RBI, then in that situation the charge is not required to be created or modified. Next, in case resolution is taking place, insolvency resolution professional will do the signing of these forms. In case liquidation takes place, liquidator will sign this form and give it to the registrar. Next, with the chapter 7 amendment, what is it? If member wants to inspect, extract, or get a copy of the register of members or an index or return of member, then in that situation, these four things will not be given. What are those? One is address of the member, next is email ID, next is unique identity number and PAN number. Next, chapter 8. Chapter 8 is talking about new insertion has been made in the insolvency IEPF. Investor Education Protection Fund. What? That significant beneficial owner, if they have not given a declaration, then the tribunal will pass an order that the shares can be credited to Investor Education Protection Fund, and also the benefit arising from that shares also can be transferred, and there is no restriction. Chapter 9. Chapter 9, one is talking about prevent where COVID related help has been done by company. This will be included in Schedule 7 of point 1 and point 12. Any research with regard to science, technology, engineering, medicine, Schedule 7.9, it will be included. Any har gar tiranga for that any mass scale production of the Indian flag has been done. This also will be included in item number 2 of Schedule 7. Where Form AOC 4 or Form AOC 4 XBRL along with this has to be filed with the registrar. Along with it, Form CSR 2 also has to be filed. In case for financial year 2021, within 30 June 2022. In case of financial year 21-22, 31st March 2023 has to be filed. Form CSR. Books of accounts, books and papers, which is in electronic mode. It has to be accessible. What is the amendment? It has to be accessible at all times. And it has to, and this books of accounts, books and papers, which is in electronic mode, backup has to be done on daily basis. And if the service provider is located outside India, then in that situation, name and address of person who's in control of the books has to be noted. Next. Any ongoing project where unspent amount of CSR is there, CSR committee has to be formed. Three consecutive financial year, the net worth which is 500 crores or more, turnover which is 1000 crores or more, net profit 5 crores or more, it has not been met, then what, you don't have to do CSR. That particular provision has been omitted. Yes or no? Yes. And company, what a new research has been done. Company, where it is section 10 of clause 23C of subclause 4, 5, 6, 6A, which is talking about charitable, religious, and education. This also will be considered as what? Will be included in CSR. Next, the final one, where company undertakes any impact assessment, they can book that particular impact assessment expenditure as CSR expenditure, but it should not exceed. What is the amendment? Earlier it was 5% of the total CSR expenditure. Now it became that 2% or 5 or 50 lakh, whichever is higher. Earlier it was low, less. Now that from less converted into higher. This is the amendment. Yeah. For any doubts, kindly mention it in the comment below. And if you like this video, do like it and mention your love, pour your love in the comment section, and do subscribe and click the bell icon. Thank you.